Hello, my name is Socrates, and the concepts presented may offend you. Enjoy.
Punishment. Part 1. The inherent problem with any modern court is that the matter of a solid conviction, there can be no doubt. Doubt of guilt, doubt that the punishment would be subsequent if carried out. Then to ask if the concept of retributive punishment is even available. Costs of jails, prisons, courts. Then to calculate the risk of reoffense. In that the contemplation of what brought that being into your presence has only been a non-obligatory statistic when using such resources separate from any legislative assembly. Knowing the conviction's validity is the lifeblood of the justice system. As to be with system means in any array of cases or situations must retain the ability to process evidence as procedure. Such procedure must follow criteria, while creating the circumstances within reason to prevent such an incident from reoccurring. In that any misuse of authority to misguide the public on a threat to themselves as listed would identify such subjects as nuisances, public nuisances, legislation relevant to the use of hearsay, or other mitigation factors such as cultured situations wherein one tamper with another's property to entice another into a private residence, or another location where the use of devices which collect context during the investigation are rendered inaccessible. Separately, the implication of using machinations or the neural imaging tech more functional and reliable evidence pertinent to investigations has not been assigned any proprietary label in reference to privacy policies in any state. Dually, the application of such charters or rights create inconsistency between the validity of evidence and the state's endorsement of such acts, in that the prior stated negotiations during Congress bound the justices and crowns of the state to said documents. In the ability to apply such technology, it's not as simple as using an officer's interview tactics, as there are strategies specifically taught in the field of psychometry in application currently. The field has not only been undermined but functionally disregarded as a focus educationally, where the use of psychologists in penal faculties are to ensure the sound mind of an inmate. The employment of psychometrists allows the proceeding to take place in combination with such technology with the precision of spectrum blood work. The situation, the database correlation, questions and the presentation of said images in reference to the case with the microphone displaying dually vocal tones of the interviewer and the subject to a jury, with a capacity to be replayed in recorded fashion before decision of the conviction. Again, relevant to privacy policies, the constituency, validity of NDAs, camera use, and the databasing of footage recorded by the public holds great relevance to the ability to uphold statutes and in doing so maintaining order and economic stability. So, to create the circumstances that would both support the use of the PPA and other acts, case law relevant to manners involving the collection of evidence, is not the predetermined ability to police relevant to the state retaining the capacity to uphold the policy it currently prioritizes. Case 1. 3 men seen walking past City Hall. 2 shorter, 1 of great stature. Their coats had vivid and notable patterns, colors. They'd walked a total of 4 kilometers from the time they were first recorded. There were reports of men holding passersby at knife point, they were described, though their faces were not recorded. This apparently went on for a total of 70 minutes. They walked north through the town past a bar doing an advert, where they had not committed an offense in plain sight, but met exact descriptions with one of the men showing part of their face. Then, up the town's hill they found the jackets emptied with no property reported stolen. If a notice of the men was made public, does the face recorded by the cell phone hold validity as evidence relevant to the investigation of the crime? Pertinent active, inactive bylaws. Filming of the public is prohibited unless there is a written agreement between relevant parties. Use of public footage for the purposes of monetization must be validated by the municipality. The footage used will be held for the term of no less than 1 year, without distribution rights. As a matter of closure, the ability to accept that if the case were closed that the person is not only incapable of reoffending in the matters of life and death or the psychological trauma that can impede said victim of a crime after returning to the workspace, that they'd lost the money protecting in the first place, as then a concurrent punishment would have been laid out for speculation. Then the proceedings having overlooked pertinent evidence relevant to the defendant's trial, using the current methods of identifying both corroborating evidence to cases that are being tried and such as that relating to other offenses, as a domestic case that holds to the complainant having been battered, may request film from others or establishments in the cases that in the defendant drinking were to have been prohibited after threats made either past. 2 kids, a house, renovations to the unit, made the front and back separate, allowing the kids to be present with both parents, while the threats turned to violence, with the cases being separate, but implicative of other offenses, where the night of the assault, the man had been out at a bar, and his drinking led to a fight, where he's been struck repeatedly. Thus, he'd not only been prohibited from the use of alcohol, but the first confrontation he'd started over the conflict with his wife, then returning to hear her having relations with a new partner. He waits until he'd left, then caught her outside and began another confrontation. These proceedings are rarely speculated upon when the opportunity for leniency is presented, in that the evidence could have been missed, or the capacity to alleviate the defendant's guilt, both to the incident and others, lands upon the ability for the diversity of the citizens' social spectrum to land abroad of the general economic, demographized projections. With the ability to expand on the tactics, legislation would not only be more effective when breached, but the ability to understand when the corruption of the statute's function comes into play through the dystemic tampering with the reasonable person's perspective, i.e. to support an illogical application of case law from a time where the morality of the nation was up to scrutiny, or to assist in the disregarding and disassembling the current inconsistencies in noting an offense, or to see in that ability to manage the case law proceeding, the bill having been put into effect then over the period of time few badly written stipulations leaving either victims of a crime or the consequences of that bill being in place creates a crack between the ability to make interpretations on the victim through causal acts, or the bill having been misinterpreted socially defuncts the capacity to note its intention in having been written. Thus a bill being drawn to prevent the gumming of the courts, like Bill C-46 in Canada, noting that there are tactics that have been used to create a perceptive inconsistency objectively in sexual assault trials. The same amendments to the bill have been made opposing to allow being intoxicated to longer be a reasonable defense or a piece of notable evidence when presented, standing if only in the eyes of those unable to comprehend the logical constitution of evidence, like shell casings in a murder not having fingerprints, but the ammunition was that of the company loaded in the seized weapon only having been replaced over the next day, to see in that ability to manage the case law proceeding, the bill having been put into effect then over the period of time few badly written stipulations leaving either victims of a crime. The consequences of that bill being in place creates a crack between the ability to make interpretations on the victim through causal acts, or the bill having been misinterpreted socially defuncts the capacity to note its intention in having been written. Thus, a bill being drawn to prevent the gumming of the courts, like Bill C-46, noting that there are tactics that have been used to create a perceptive inconsistency objectively in sexual assault trials. The same amendments to the bill have been made opposing, standing if only in the eyes of those unable to comprehend the logical constitution of evidence, like shell casings in a murder not having fingerprints, but the ammunition was that of the company loaded in the seized weapon, only having been replaced over the next day.
Like, subscribe and click the bell for notifications.